Okay, welcome. Happy Sunday in week 9 to you all. Firstly, my apologies. A few of you would have gone last night to the Law Society dinner. I hope you had a terrific night. Unfortunately, right at the last minute, I had some unexpected things to show up that meant that I couldn't be there, and I was very sorry not to be there. In fact, it was so urgent I didn't even get to submit my apologies until very late in the evening. But hopefully you met a few new people, and those of you who were there had a good time and feel much more part of what's going on. I have put up a poll this week. When you've got a chance, just have a look. It gives me a sense of how you're going and whether I need to slow down, speed up. Of course, you can ask me questions as we go. You're all on mute at the moment, so I'm trusting you to go off mute and to call out. There is a chat, but it is actually very hard for me to see and react to the chat when we're going. And I can see we've got a few people joining us as we're moving through. So if you wouldn't mind, have a go at that. Before I start, I do want to talk to you about some content for this week, because we're going to run out of time otherwise if we don't use some of this time to look at that content. But I really want to start with questions, concerns, frustrations, comments before we get started, give you an opportunity to either ask me anything or to help me focus what the discussion is going to be today. So over to you. Anybody? While I drink tea. Okay, so everybody's very quiet at the moment. If you need to unmute, I'm looking and I can see everybody's muted, so I'm assuming that it's intentional that I can't hear you, but you really do need to yell out if you need to ask a question. And what I want to do is start then looking at the next topic that we have, which is talking about the contents of a contract. So hopefully you can see something. I'm not entirely sure what you can see. Let me just do that again because it didn't look like it was working the way it should. Okay, can somebody just give me some sort of signal that you can see a slide that says contents of a contract?
Yep, can see it. Thanks, Kat.
You can see, great, thank you. It's very quiet today. I think today is one of those days where I'm going to prefer face-to-face teaching, I can just tell. Okay, so the topic that we're up to is express terms. But I want to actually stand back before we get started and talk about the next 3 topics and how they fit together as we've moved beyond now understanding what it takes to form a contract, understanding what some of the key elements are that might affect the enforcement of a contract once it's formed, to move on now to our discussion of what the contents of a contract are. So effectively how that's going to play out is that we're going to start with this overview of contents, but then we're going to talk about express terms, implied terms, and then how we understand the terms. Now, I'm saying that in a way that makes it sound like we're going to do them sequentially, and to an extent we are, but you will find that we necessarily move backwards and forwards and that we're a little bit muddy in this area as to precisely what the content is, particularly as what you will find is that we're dealing with construing the terms in an as we go basis. So we will be looking at contracts, we will be looking at both express and implied terms and working out what they mean as we go, rather than doing this as a separate topic. So really where we are going to start is by focusing on the express terms themselves. And this is kind of my favourite part of the course because, as I often say to you, in my transactional life, I've been a lover, not a fighter. I'm a person who's really much more interested in this space here, in the creating of the transactional documents, rather than the hustle and bustle of the world of negotiation of disputes or settlement of disputes. But clearly, we read the disputes, the cases, in order to understand what it is that we're doing, but we're doing that in part so that we can learn how to write a contract. So it's an important part of the process. Hi, Aisha, I can see you there. Okay, so that's where we're at. So what I want you to do from the beginning is start by taking a step back and thinking about how everything fits into our bigger plan. So we've started off with the elements. You know them off by heart now. Agreement, which usually comprises offer and acceptance, but we might, if we can't see those two, then we will find consensus. An offer effectively contains the DNA of the deal. So we've spoken at length over time about how the offer needs to incorporate all of the other things that we need in order to demonstrate a contract. For example, we need to be able to see from it that if it's accepted, what the consideration will be. What it needs to be sufficiently certain, legally certain, and it needs to demonstrate to a person to whom it is made that there is an intention that both the offeror and the offeree will be bound when that acceptance is communicated. We've then moved on to talk about a number of matters affecting formation. We've spoken about privity, so who the parties are. We've talked about formalities, the extent to which sometimes documents need to be in writing or agreements need to be in writing. And we've also discussed capacity to contract. Now, none of these things go to whether there's a contract or not. They go entirely to the question of whether that contract can be enforced. In fact, in the case of capacity, we can end up with a contract that might be enforced against a party, but not by a party. So a party, if we're dealing, for example, with a contract for something that is not necessities and is not a beneficial contract of service, where there is a minor involved, the minor might be able to enforce that contract against the other party, the vendor, but the vendor cannot enforce it against the minor. And now we end up in this final part of, the final part of the arrangement where we're looking at, once we've got that contract, what are the terms of that contract? So that's where we're headed now with these next three topics, which I think is topic 9, 10, and 11. And topic 12 is in fact not a topic, it's revision, because yes, that's how far we are away from the end of the semester. So we are basically the whole way through, we've been scaffolding up to being in a position where we can start with asking, do we have a contract? If we have a contract, is it enforceable? And once we work out that it's enforceable, then we're working out what it says. Unfortunately, though, it's very rare to get this straight sequential approach, that we often need to move backwards and forwards. And so that's what we'll be doing over the next couple of weeks or so. Now, clearly, this is all very relevant to this assignment that is due in a week's time. So it is important for you to really get your head around this. Take a moment, if you will, by the way, to do the little survey, the little poll that I've got running on the side at the moment. I've only got one person who's done it. Of course, I don't know who does them. But at the moment, everything's sort of sitting in the middle. It's interesting without being too challenging, but not being really rewarding. And basically on a scale of 1 to 5, we're somewhere around the middle of between being very confused and very confident that we understand what's going on. So all the things that we're doing over the next 3 weeks have been designed to make sure that we understand what the terms of an arrangement are or an agreement are. And we're going to do that by looking at express terms. We're going to look at what the meaning and legal effect of the terms are. Where there is a gap, we've got to consider the extent to which, and we've started doing this in previous topics, that the court can fill that gap, and ultimately ask ourselves in what circumstance a party can avoid responsibility under a contract. So these sit with the objectives of this topic: to categorise pre-contractual oral statements, to determine the express terms of a contract, to examine the Parol Evidence Rule and the exceptions to it, to distinguish between conditions and warranties, to understand the effect of exclusion clauses, to comprehend how exclusion clauses are incorporated into a contract and how they'll be interpreted, and to examine when terms will be implied. So there's a lot to do over these three topics that fit together. So how have I approached it? This is a bit of a mind map here that will show the flow. This is where we're starting today. Oh, sorry, this is what we've already done. We've done the formation elements, okay? Right now, we're going to sit here in topic 9. So the express terms. Sorry, I've got a little eagle with my pencil there. So basically what we're going to do is unpick each of these elements. Then we're going to scoot from 9 to 10. We're going to start talking about how the courts will fill the gaps, which requires us to examine implied terms. So we can only, if that makes sense, what we're doing is asking, what are the terms of the contract? What do they mean? Are there any gaps? Can the gaps be filled by some kind of implied term? So we start with what the express terms are, the terms that we know, move to implied terms, and then over the next week after that, we'll explore the rest. But of course, we're going to have to continue to explore the Parol Evidence Rule as well. And so I want to spend a little bit of time discussing that today as well. Why do we do it? Terms articulate the precise rights and obligations of parties under a contract. Each party needs to be in a reasonable, should be in a reasonable position to understand what they must do or what they're not allowed to do in order to perform a contract. And any dispute relating to the performance or the non-performance of the contract can be resolved by evaluating the party's conduct against the terms of the contract. So the terms are the rules of the game. If a party's deviated from their contractual obligation, if they have breached their obligations under the agreement, then they have arguably breached the terms of the contract itself. And this might give rise to a claim for breach of contract. And ultimately that leads to requesting a court to enforce a contract, which means ordering a party to remedy the breach, but it might also mean seeking some kind of order of specific performance requiring somebody to do something under a contract. And we spoke about that in class last week, and I suggest if you haven't listened to the recording of that, if you weren't there, that you should head back to that class to understand these ideas. So before I go on, can I ask you a little bit of participation here? Where will we find the terms of a contract? Where would we be looking for those? Anyone? Come on, somebody must have some idea where we might find the terms of a contract. I can see you just waiting me out. I can see the chat at the moment. Does anybody want to feel more comfortable sharing in writing where you think that the terms might be found?
Sorry, Kath, I was away from the computer. Where you could find terms of the contract, anything that's been written up previously?
Oh, Will, I think you're speaking, and because I haven't had anybody speaking, I haven't realised that I can't hear anything at the moment.
Ah, okay.
That's not good. Let me just see what's happened here.
Can you hear me?
Okay. Guys are off the
better?
hook because I can't hear you at the moment. I'm on, this time I can see somebody is speaking. Okay, hopefully that should work. Can you speak again, Will?
Is that working now, Kath? Hello?
Don't know what's going on. This is ridiculous. No, I don't want to disconnect my speaker. I want it to continue working. One more time.
Kath, working, testing. Testing.
Okay, I don't know what's going on. Give me a second. I'm just going to have to stop sharing to change the speaker. Discard those. Go down here. Sorry. Okay, third time lucky. Should work now.
Testing, is that working?
Whoa, thank you. I feel like I've been here alone in the wilderness.
No worries. I was just saying I was away from key, but got I think the last time you repeated the question. I would say you would find some express terms in any form of written correspondence or agreement on what the parties sort of want to get out of that contract or their agreement to contract. Yeah.
Anything else? Where would you look?
Express term. Express term. I'm not sure where else. I would say verbal, but I don't like the certainty on that one.
No, it's fine to be uncertain, but absolutely any expression of what the terms are, any place where you can express a term would be a source of a place where you find express terms. So it could be anything in writing, any exchange of correspondence between the parties. It might be, as you mentioned, a formal written down agreement. It might be conversations that parties had with each other. Many contracts are made every day without any writing whatsoever. So we can express terms using our voices or even just our actions. Like we know already that silence is not by itself enough to constitute an acceptance and to make an agreement. But if I make you an offer and you indicate your acceptance in some way by nodding your head or giving me the thumbs up sign or something similar, then we create an agreement. So one of us might do that by a sign, a notice, a ticket. We've looked at all sorts of different sources for that information. So, oh gosh, now I'm really not having a good couple of days. Now my whole slide pack has decided to close itself down. Here we go. I found it again. Let's start from there, and I will go back to sharing it with you in just a second if I can reduce the size of this ridiculous set of notes that I have. Okay, and then the next thing I need to do is share the PowerPoint slideshow, share. Okay, you should be back on now. So just moving forward through that. So basically, terms can be recorded in all sorts of places. They will look at any of these things. Any communication between the parties is potentially a term. So what does the court use as a guide? It'll think about the significance of the documents or the exchanges to the parties. It'll think about whether or not something has been incorporated by notice, whether that is literally a notice or a sign, or whether it's a link on a website or some other way of accessing information. Of course, we've also, so what we're going to do in the express terms is the stuff that hopefully you can see, it's quite a faint highlight there. But we will also look next week at terms that are implied by statute. or terms that are implied by law. So in a very limited number of cases, there will be a requirement that specific terms are always included in certain types of contracts. Or in other cases, unless they're specifically removed, that the terms will apply. Now, you've already come across that. So let's think about an example where you've come across that before. You will remember the postal acceptance rule or the postal communication rule. That rule, which comes from the case Adams and Lidzel, I always say that party name incorrectly. In that case, it was demonstrated, the proposition is that the parties, that a communication will be deemed to be received by a party if it's sent by post at the time that it's put in the post. So if you have an ongoing contract with somebody, say Will and I have a contract, and I have to send him, I don't know, I have to send him pictures of Mount Fuji every time he sends me a notice requiring that I do so. And he can send those notices by mail, or he could send me SMSs. I don't know why you want those pictures, but hey, I've agreed to do that. You're paying me handsomely for it. So if I have to send them within, let's say, 24 hours of the date that I receive the acceptance, unless we do something to override the term in at that would otherwise be implied by law, basically my obligation would be to send within 24 hours of when you put it in the post. Because there is effectively, the way that the law works, a term that says that acceptance or receipt is deemed to occur at the time that it gets put in the post. Make sense? I hope so, because all of you have cameras off and I have got no idea today.
Yeah, makes sense, Kath. Thanks.
Thank you. I need feedback today. It's been a tough weekend. I need feedback. So what factors, I just started talking about this, the kind of factors that the court uses as a guide. These are the kind of things that we're going to be talking about as we go, because there's no one consistent rule. And you've got to be thinking about these things when you're writing contracts and when you're dealing with problems, because you've got to be thinking about what would the court do if we don't specifically deal with this issue? And has this issue been dealt with in a specific way before? What will be implied? What happens if it's left out? How do I express it to make sure that it actually represents what it is that my client wants and that the parties have agreed? So there's lots of different ways of categorizing different terms under a contract. And we tend to think about it as this express terms versus implied terms, but that's still a very loose way of categorizing, really. So the express terms can come from a range of different places, as is mentioned: written agreement, notices, tickets, oral statements, websites. It's supposed to be a website there, don't know if it showed it. All these places where you can get express terms. We also have implied terms. We'll go into these in more detail next week. They tend to come from either the law, custom, or fact, what reasonable people would expect. Might have been a course of dealing or otherwise. Sometimes we will have an overlap of the two. There will be some express terms and some implied terms. Sometimes when we have a written agreement, because of the operation of the Parol Evidence Rule, we actually can't see any of these other things. We might have to, in certain circumstances, deal with this. So, for example, there is a statute that provides that door-to-door sales anything that's sold door-to-door must be in a written agreement. But it also includes, so there's a term that's required by law rather than implied, but if it's left out, it will be implied, that basically provides for a cooling off period. So if somebody comes, knocks on your door, sells you something, they have to give you a document in writing. It should contain a term that says you've got 7 days to change your mind. If it doesn't include that term, then that term will be implied by the law. What else okay, so let's just think about what these express and implied terms mean. So express term can be quite straightforward. An express term is basically a term which derives from something that has been expressly stated in words by one or more of the parties. It could be made orally, as Will just mentioned before, or it could be in writing. So I offer to sell you my car for $500. If I put it in writing or I made it orally, it embodies an express, it's an offer. It's an express term. My car, you can work out what car it is. Actually, I don't actually own a car. That's a good thing. Because if I sold my husband's car for $500, I'd be in a little bit of trouble, I suspect. Some contracts will contain terms that are partly writing, partly oral as well. So, actually, I've just mentioned this. So this is this overlapping space here. Okay, what else do I want to say? We can continue to categorise. Now, why do we categorise? Because sometimes it helps us solve problems, and that's really what you're needing to learn to do. So again, we can identify what the terms are, and we'll talk about the difference between a condition, an intermediate term, and a warranty shortly. We can also identify collateral contracts, and I want to talk about them very briefly today. And then we also have this idea of representations. So some representations will be promissory in nature and they become terms. Sometimes we will be wanting to, or one of the parties will be wanting to ensure that some sort of promissory statement is brought into the contract, but because the document is otherwise in writing and so this term might be excluded by the Parol Evidence Rule, we might be trying to show that it's a collateral contract. When the promissory statement is made, we need to be clear about whether it's a condition or a warranty or something in between. Promissory statements might also be misrepresentations. So it might look like it's a promissory statement, but ultimately misrepresent what the situation is. And these are dealt with by Section 18 of the Australian Consumer Law. And we've spoken previously about puffs, but it is quite important to be able to differentiate a promissory statement from a puff and a promissory statement from a misrepresentation. So I keep talking about the Parol Evidence Rule. What is it? I think the best definition of it comes from Justice Innes in Mercantile Bank of Sydney and Taylor, which is a very old decision now, a New South Wales Supreme Court decision back to 1891. But you'll see that this definition is quoted with authority many, many times. So the Parol Evidence Rule can be explained as follows. Where a contract is reduced to writing and it appears to be entire, it is presumed that the writing contains all of the terms of it and evidence will not be admitted of any previous or contemporaneous agreement which would have the effect of adding to or varying it in any way. So let's unpick that bit by bit. Where a contract is reduced to writing. So that's our first piece. So one of the first questions we have to ask ourselves when we're looking at what the terms of a contract are is we need to ask ourselves, was it or any part of it reduced to writing? Is there writing representing what the terms are? Interestingly, in our modern society, where there is so many invitations to treat are accompanied by terms. So it's actually the person who is inviting someone to treat provides the terms and conditions contemporaneously with the invitation. Then an offer is made by the purchaser of goods or services to purchase those goods or services on the terms that have been provided by the vendor, and then the vendor accepts. So the writing traditionally would have been put together by the offeror in most cases, but that's less and less true these days. Similarly, it's actually quite unusual in any real commercial arrangement for there to just be one document. parties will go backwards and forwards and negotiate a document, particularly in a complex situation. So first question is there writing? Next, is it an entire piece of writing? Does it appear on the face of it that the writing represents all of the terms and conditions? So again, this appearance is interesting because it's possible to bring evidence to demonstrate that it's not, that the writing is not everything in the document, in the agreement. So that's part 2. Let's number it as such. Oh, that red on the green is somewhat nasty to look at, isn't it? So then, once we've got those two, writing and appears to be entire, it's presumed that the writing contains all of the terms of it here being the contract. And evidence will not be admitted of any previous or contemporaneous, so prior to the agreement being made or at the time that the agreement is made, of any evidence which would have the effect of adding to or varying the contract. So this becomes quite interesting in itself because the rule ultimately will ask us from time to time to question also, does that exclude evidence that might explain what the parties meant by the terms? And often that becomes the dispute. Questions, concerns, frustrations, comments? So the rule itself, again, like many of these rules, we're going to try and understand it and see it in action as much by thinking about how the rule works as understanding the exceptions to it. Now, some of these, in my view, are not exceptions, but really explanations of how the rule works. These are pretty much taken almost directly in the same order from your textbook, which has some really good explanation of this rule. But it is really important to get it into your head about how the contract works itself and what happens when we have an entire agreement reduced to writing. So when does the Parol Evidence Rule not apply? So the first and in some ways most important exemption is when we've got a partly written, partly oral contract. Now, if we go back to the previous definition, we can see that that's not really an exception to the rule because the rule applies when a contract is reduced to writing and it appears to be entire. So if we're in the situation where the agreement is not entire, and it's not really an exception to the rule, is it? It's a circumstance where the rule doesn't apply. But often you will need to be able to bring evidence to demonstrate that the writing doesn't represent everything in the contract, again, which can be quite difficult, particularly as a court will look at how serious the documentation is. If it looks and smells and feels like a well-worded, formal document that the parties have signed, then it is much more likely to represent an entire agreement than an exchange of emails, a couple of text messages, and an invoice with some terms and conditions on it, or a gathering of documentation with writing on it. So the second exception that we have here is contracts impliedly subject to some trade usage or custom. Now we'll deal with most of these in not tomorrow, but Monday hence. But there are a number of kinds of contracts where often there are just very short form documentation because there is such significant trade usage. So a good example of that might be trading shares on a stock exchange, probably up until computers and financial services rules changed everything over the last 20 years. But on a stock exchange, if you wanted to buy or sell shares, say up until the 1980s, you would just contact your broker and you would transact with your broker. The broker would then go into the market, literally, physically go into the market, find someone who was, say you want to buy, somebody who wanted to sell, who was a broker who was acting for someone who wanted to sell those same shares, and then would, within the scope of their instructions, you would have a match of a buy and a sell price. And basically the rules work the same way. Back then, I think it was T+6. So the date that you reached agreement, the transfer would happen 6 days later. The terms, they would always be ordinary shares. They would have to be listed. So there was a great deal of trade custom and understanding as to how the process worked. All of the contracts were executed in the same way, under the same terms. So you didn't need to have significant additional terms. And it was only if you did a private sale that you might add additional warranties or promises, say, for example, that the shares were unencumbered so that they weren't subject to some sort of mortgage or security interest, or that you did in fact own them, or that you had permission from the person who does own them to sell them, that kind of thing. The next category are contracts, the operation of which is suspended by an oral agreement. Again, this is not really an exception to the rule, but another set of circumstances where the rule doesn't apply. So if I have entered into that beautiful written agreement that I entered into with Will, I mentioned earlier, to send him a picture of Mount Fuji every time he sends me a notice asking me to do so. We've agreed the consideration, we've done everything, we've formed a contract. And then at some subsequent time, basically Will has said to me, I don't think I've got the stomach for any more Mount Fuji pictures. Let's suspend our arrangements for the time being. Are you happy with that? And I say, well, if you give me an advance payment earlier than was due for the next month, I'll agree to suspend it for the next 3 months. So we negotiate an arrangement to change or vary or suspend the contract for a period of time, but we do that entirely verbally. Effectively, there's consideration, there's an offer acceptance consideration, there's an intention to be bound. The subject matter of our contract, which might in fact be called a collateral contract, the subject matter of our verbal contract is the suspension of the written contract. Evidence of our agreement, even though it's verbal, could be brought in some sort of action that Will brought against me for failing to send him Mount Fuji pictures anymore, because we have entered into this arrangement, and the contract that we're actually discussing here is a contract to suspend the written contract. If a contract is invalid in some way, even though it's in writing, then evidence can be brought of the invalidity. Pretty straightforward, really. Mistake. Now, you cover mistake in significantly more detail in advanced contract, but it is worth noting here that if there is a mistake, fraud, error in the execution of the agreement, particularly in circumstances where somebody is mistaken as to the subject matter or some important detail in the contract that they are then required to sign or induced to sign based on that mistake, then evidence under the Parol Evidence Rule, or the Parol Evidence Rule we set aside so that evidence can be brought of what was actually said and what their actual understanding of the circumstances were. And then lastly, again, I would suggest that this is not an exception to the rule as such, as just a differentiation from the rule. Evidence can be brought to resolve ambiguities or uncertainties, to help the court make sense of what is written, as opposed to vary or change what is written. So if we go back and look at the rule again, the rule says that we can't bring anything to add to or vary the contract. Very important, but it doesn't prevent us from bringing information that will help us understand what the terms are. So Paterson actually suggests that when we're thinking about finding what the terms of the contract are, that we use these 6 steps. That we start by asking ourselves, is there a written document? Is it signed? What's the effect of that signature? Now, you all remember Fong and, I always call it Fong, Chong and Fitness First. That's restating a very ancient rule it's called the Rule in Lestrange and Graucock. We'll talk about that tomorrow night. And that, since Toll and Alpha Farm, has been very clearly part of Australian law. So effectively what that says is, if it looks like a contract and you sign it, even if you didn't read it, you can be assumed that you understood that you were going to be bound by it. So unless there is some kind of fraud or mistake or inducement, if you thought it was something different or something was hidden from you, completely different. But if we've got a written document and it's signed, then we're going to have a starting point that we've got an entire agreement in writing. And if we've got an entire agreement in writing, then that is the source of the terms of that agreement. That's where we find them written down. The next step is to ask ourselves, is it possible that express terms have been incorporated by notice in some way? Have they been incorporated by notice? So whether that is a sign, a ticket, a website, an email, some sort of oral statement, are they in addition to the written terms? Is it clear that the agreement is partly verbal, partly in writing? What does that mean? The next step is to ask whether terms could have been incorporated by some course of dealing. Is this a regular arrangement of some sort where the parties understand how the process works? Say, for example, getting on public transport in Melbourne, through a course of dealing, you understand that you need to swipe your ticket when you get on and get off a train, but you only have to swipe on a tram, and you don't have to swipe off on a tram. And in fact, you don't have to swipe at all, provided you contain your tram trip into a particular area. Completely confusing to tourists all the time. I'm constantly being told by my visitors that public transport here is very confusing. But at the end of the day, even though and you could find the terms written down somewhere, they would also be incorporated by notice. But through a course of dealing, people who regularly take public transport in Melbourne understand what the terms are. Next, is it possible that statements made by the parties in negotiation have been incorporated? And we'll go through some of the rules for working out, well, what is incorporated and what's not incorporated. And we've already done some of that work. The last couple of weeks, we've talked about circumstances where the courts have looked at, in determining whether something's an essential term or not, and looking at whether it should be included or not, they've taken into account things like the parties negotiated in this particular area and couldn't reach agreement. So clearly that means that there was no agreement. But you will also remember that the way that the law operates is the courts are more likely or predisposed to find an agreement where something looks like an agreement, rather than to just find it nudum pactum, to find nothing. So if they can find a sensible way of finding an agreement, then they will do so. The next thing, step 5, is to think about whether the statements are sufficiently promissory to be regarded as contractual. So this actually takes us back to that idea of intention, really. Are these promissory statements or not? Are they intended to be binding, or are they just made to induce somebody to negotiate, induce somebody to treat with them? Are they puffs? Are they something else entirely? And then lastly, Paterson, Duke, and can't remember who the other person is off the top of my head, suggests that we ask ourselves whether the Parol Evidence Rule operates to exclude express statements or notices that are extrinsic to the written agreement. So are we just bound by the Parol Evidence Rule to stay within the confines of the document or documents that make up the agreement? So that's really my sermon for you today. I've raced through because you haven't interrupted me. When we start tomorrow, I really want to start with the actual cases of working through each of these, but I wanted to provide that sort of background overview first. Has anybody got any questions, comments, concerns, frustrations, compliments?
Hi, Kev. It's Kevin here.
Hi, Kevin.
Hi. I just got a question. If it's a pure oral agreement by two parties, and the two parties didn't negotiate about the termination terms. So
Yeah.
if the two parties have been performing their duties, and all of a sudden one party wants to quit about the agreement, can the other party continue to perform his duty and then enforce the agreement?
So, really good question first. Love it. So what we've got here is a purely oral agreement.
Yep.
And the oral agreement, we've got to assume that it's for some kind of ongoing subject matter.
Yep.
And we're going to also assume in this circumstance, but whether we do it, it kind of doesn't matter for this purpose, but we're going to assume it relates to something where there is no formalities requirement, where it doesn't have to be in writing. So effectively, then one party wants to terminate.
Yep.
The other party doesn't. So I'm going to throw it open to the floor because I think we've done enough to think about how that might work. So we've got to work out, well, what would happen in that circumstance?
Yep.
So what kind of test do you think a court would use to determine how you can terminate an ongoing arrangement like that? What kind of things would a court look at?
Would the court still look at the intention of both parties? Like whether...
Yeah, I think the court would look at that. They'd look at it objectively.
Yep.
So we're not interested in subjective intention as such, but we're interested in, sorry, let me see if I can get a whiteboard to share with you and we can draw some of this stuff up. But yeah, they will look absolutely to what the intentions of the parties are. Sorry, I'm just assuming that you can see that whiteboard still. So we'll look at intention. And we'll need to do that subjectively. We'll also need to, so because we're, sorry, subjectively, what am I doing? Objectively. So looking at objective intention too, we're starting to sit into the area of implied terms, but what a court would look at is what's reasonable. So, and it might also look at a course of dealings.
Yep.
So let's say that it's kind of easier if we've got some context here. Let's say you and I have a verbal agreement where I provide consulting services to your business.
Yep.
And usually I promised to make myself available for at least 10 hours every month. And I'm going to give you consulting services and you can call it on me day or night and I just need to make myself available. And let's say you pay me 30 days after the end of the month. So I just rack up my hours and sometimes it's 10 hours, sometimes it's 40 hours. It just depends on how busy we are. But even if I only do 2 hours, you've got to pay me a minimum of 10 hours because our arrangement is such that I need to make myself available. So I'm saying no to other work to just make sure I'm available to work for you. And we've done that. And then you've just decided my advice is crap. I'm not very useful. You could sue me because I've given you crap advice, but that's not the subject matter of that question. We can come back to that another day. Instead, you've decided you just want to terminate. So you get to the end of the month and say, thanks, Kath, that's great, but I'll pay you at the end of the month for what you've done so far, but we won't be needing your services anymore. So then it'll become a question between us as to, well, is there an implied term that you would give me 1 month's notice or 6 months notice or or whatever. And how would we work that out? We'd work it out by looking at the course of dealing between us. How long have I been working for you doing that? Have we ever had any sort of discussions about what kind of notice period there would be in the past? What's usual in our industry? I don't know what, let's say your business is anthropology or archaeology, and I consult with you on dinosaur bones, and there's only so much dinosaur bone consulting out there. I have made myself completely unavailable to your competitors because that's the promise that I made to you, and now it's impossible for me to get work. If I've made myself unavailable, if I relied on the promise in some way, then the notice period might be longer than if there's tons of available work and we never made any of those promises and it doesn't matter. So again, the termination, firstly, it's just like, well, what's reasonable in the circumstances? Secondly, it's if this is the nature of the contract is that there would be likely a term about what termination looks like, then there are some things that the courts can draw on to imply that term. Is that helpful?
Yes, that's quite helpful.
So I think it's an excellent question, because often the problem we have in understanding a contract is not understanding the terms that are in it, but identifying what's missing. That's the really tricky piece here, identifying what's missing. Any other questions, concerns, frustrations, comments? Did I miss a good party last night? I was very sorry not to be there. Of course, I'm not sure whether any of you were there. I'm going to take that on the basis that you possibly weren't if you're all quiet about it. But yeah, unfortunately, I was pulled away at the last minute, so I was sorry not to be there. All right, well, if there's nothing more, again, completely open to any questions more generally as well. That's what shoots are for. But otherwise, I will finish it up. It's 7:24. Okay, guys, well, looks like we're finishing up. Thank you for your time and attention tonight. It's busy end of, oh, sorry, I've got somebody on chat. Let me just check that. Oh, sorry, that's Kevin, that's your question. So good, now I've seen it. Thank you all for being here tonight, and I will look forward to seeing some, if not all of you, tomorrow night in class. Stay warm, won't you? It's getting cold now. Take care.
Thanks, Kath. Thank you. See you tomorrow.
Cheers.
Cheers.
And end meeting. Bye.